Okay, so as we said, in Tinker case, the student rights of expression are not limited, and the courts indicated that if a disturbance was about to occur or is imminent, that the freedom of expression is limited. There are two court cases. They begin talking about them on the top of page 26 in the Green Book and bottom of 19 going over to 20 in the Purple Book. The two cases are Bethel, the indecent speech case, and they go into great detail here. I can probably summarize it. The Bethel case was basically a student who got up and made a speech in an assembly nominating somebody for a student office, and he used all sorts of sexual innuendo, and the school suspended him for doing that. And the Supreme Court eventually ruled that this was within the rights of the school to do that, that the kid had gone beyond his rights of freedom of speech. They did it because there was a captive audience, because everybody was at the assembly. Some of the kids were 14. Of course, any 14-year-old knows every sexual innuendo you ever do. If you don't know that, you'll find that out.
Some we don't know.
Yeah, so this is the ones that you don't know that you have to watch out for. But anyway, so the court affirmed the decision that, and eventually it went to the U.S. Supreme Court. And the Supreme Court decision is at the very bottom of page 26, not the indebted one, but in 2/3 down on page 20 in the Purple Book. Because the lower court had had said the school district was wrong, and it explains that their vulgar and lewd speech. The court had at one time the 7 filthy words doctrine. So there were 7 filthy words. Now there obviously are more than 7 filthy words today. But anyway, the court said it was the school. The key was, I think, that there were 2 things. One was that it's within the school's jurisdiction to insist on decorum on the part of their students. So the school has the right to do that. The other one was the court went back and contrasted it to Tinker. Remember the black armband? And they said it was different because the Tinker was an exercising of their constitutional rights on a political issue, which was the war, and this had nothing to do with politics or with any type of expression like that. And basically that pretty much covers it. It's Bethel versus Frazier. Bethel. Let's see. And a new case. I don't know whether you have it in your Green Book or not. Right at the end of Bethel versus Frazier is in 2000. Well, you really don't, because this is 2007. Case Morris versus Frederick. In Alaska, a high school student was disciplined for displaying a sign reading "Bong hits for Jesus." And the Supreme Court, in this case, again found in favor of the school. Hazelwood case, I understand there are a couple of questions about Hazelwood, which is controlling student press. One true-false question is controlling underground paper is easier than school-sponsored papers. And that is actually false, because school-sponsored papers, but the court's going to rule in favor of the school because they edited out a couple of stories out of the school newspaper. Part of the responsibility of the school is to teach students who are taking journalism and writing the paper to be responsible in things that they say and everything like that. An underground paper is different. than that because it is not under school sponsorship, so the school loses that control, although that's pretty shaky. I understand there's a question like that. I question the question. But anyway, shifting to page 28 in the Green Book, and we're still on 21. The courts have basically extended this to theatrical productions, school-sponsored activities, other expressive activities that student, parents, and members of the public perceive bear the sanction or approval of the school. So it's the same idea. Okay, then turning the page, they go on and on about this for a little bit longer. Page 22 in the Purple Book, and we're still in the middle of page 28 in the Green Book. And there's just a summary there of, again, the Hazelwood case. You don't have to know that much detail. They'll just ask you a true-false question or something like that. Student publication guides, I don't think you need to know anything there, but you're jumping over in the Green Book to page 29. Student conduct off school grounds is the next, and the student conduct off school grounds is the same as if the activity took place on the school property. So when you're off school grounds and it's a school activity, then the schools are still have responsibility and have jurisdiction over students. Gang activity at the bottom of that page, page 22 in the Purple Book. I'm not sure whether it's on 29 in the Green Book or not. Because of all the gang activity in Nevada, the legislature passed a law aiming at preventing intimidation of students en route to and from schools. And it basically said that it's unlawful for a person against the will of a pupil attending a public school to beat, whip, detain, or otherwise interfere. Is that in your Green Book? Okay. So I don't need to read that to you. So actually the schools have pretty much jurisdiction over when the kid leaves his house until the kid returns to his house. And so that means on buses and things like that.
30 seconds.
30 seconds. We're
Mhm.
moving over to student suspension at the top of page 23 of the Purple Book. And after the first three paragraphs, we'll go from 29 to 30 in the Green Book.